Welcome to the show for legal shit you seriously ought to know. Alright, so first off, this thing right here, it's the bomb, Ceremonic. Highly recommended. Amazing shit. So today we're going to discuss a little defamation. We're going to discuss the Trump lawsuit against the New York Times, and by the time we are done, you will be a little quasi-mini expert in defamation. You'll be able to impress all your friends, all your enemies. Your knowledge is going to be off the charts. So, first item that we need to discuss is that the lawsuit is taking place by the campaign. It's not being carried out by Trump individually or in his official capacity as president. It is his campaign. It is a separate entity. Okay, and it concerns the 2016 election. Now, I heard somewhere that apparently a group cannot sue for defamation, which I find to be absurd and ridiculous. I have a hard time believing that, since groups sue for defamation all the time. The NRA sued, Scientology has sued, various religious groups sue all the time, so I don't know about that one. It's a little hard to fathom. But anyway, moving on. So what is defamation? It's pretty simple. The general definition is a false statement of fact. False statement of fact that exposes a person to hatred, ridicule, scorn, obloquy, humiliation, etc. publicly, or injures them in their trade or business. So that is the general definition, common law definition, and remember, offensive statements or words cannot be the basis for defamation, period. Now, what is this lawsuit based on? The foundation. It concerns an article published in March of 2019 in New York Times op-ed. Op-ed means opposite the editorial page. It's used to generally express opinions by people who are not employed by a newspaper. So this was an op-ed, and it expressed an assertion that Putin and Trump had a quid pro quo arrangement, in that Putin would help Trump be elected, and then Trump would amend U.S. foreign policy in favor of Russia, in favor of Putin, remove sanctions, etc., that kind of thing. Pretty basic, pretty standard stuff. So you should know, you need to know that truth and opinion are protected. Okay, truth and opinion are protected. They cannot be defamatory. So shortly after this article came out, a few weeks later, the Mueller report came out. It completely rebuked all the allegations in the article. It completely discredited any assertion that there was collusion between the campaign and the Russians. There was no evidence whatsoever to this effect. And so the New York Times cannot claim truth of this article as a defense. So no reasonable person would accept that as a defense. If you're unreasonable, that's your problem. So opinion is the only defense that they have at this point. Now, what is defamation in New York? The case was filed in New York Supreme Court, so New York law will apply. The definition is a false statement. There's four parts. False statement, published without privilege or authorization, published negligently, and causing defamation. So we just discussed what defamation is. It exposes a person to hatred, ridicule, obloquy, humiliation, etc., or injures their business or trade. So let's talk about the third factor in a second. The first factor, false statement, that's easily provable. I don't think that's beyond dispute. It was a false article and published without privilege or authorization. That's also, it appears to me, definitely that factor will be met, because there's no privilege that would apply here. They can't claim fair reporting privilege. That would not be applicable in this situation. There was no authorization. So let's talk about the third standard, negligently. This particular standard, the third factor, applies to private persons only, so non-public figures. Okay, so we have to go back to 1964, New York Times v. Sullivan. Again, New York Times involved in this, where the Supreme Court changed the standard for defamation for public figures, for celebrities, for government officials, etc. So in their infallible wisdom, the Supreme Court made it much more difficult for public figures to sue for defamation than private persons. They created a parallel system of justice for public individuals. Okay, they replaced the third factor, negligence, with actual malice. So actual malice does not mean hatred, ill will, anger, or malice, etc. That kind of thing. It has a specific legal definition, and it concerns the state of mind of the publisher at the time the article was published. Okay, so the specific legal definition is that to meet actual malice standard, a statement must have been made that was knowingly false or with reckless disregard for its truth or falsity. That is commonly known as the definition for actual malice. Okay, very difficult to meet. So, what does the future hold in this situation, in this case? Who the hell knows? I have no idea. Obviously, it's an uphill battle. Cases that claim actual malice are rarely successful. Okay, so the Supreme Court decided that public discourse and publication of a multitude of a wide variety of articles, of media, is to the public's benefit. It is to the benefit of public discourse. There's a social good, whatever, to the unfettered expression by the media of its whatever they want to publish, basically, and they don't have to be 100% correct. So that's definitely a part of the decision. So generally, that's what they decided. Okay, so if the plaintiff, if the campaign survives the initial motions to dismiss, like summary judgment and maybe standing challenges, I believe that it's going to fall into the discovery. So it'll be up to discovery to get the evidence that is necessary to be able to show actual malice. They're going to obviously go into the communications between the Times and the author of the article. So let's say, did they have an idea that the article was false, and did they go ahead and publish it anyway? That would not be good for the defense. Okay, did they have an idea, did they discuss at all that the article might be crossing the line between opinion and factual allegations, factual assertions? That would also be pretty bad for the defense. So the author is most likely will be deposed. They'll be questioned as to their state of mind at the time of writing the article and publication. What was the informational basis for the article? Where did they get this information? Was there a governmental leak that provided them with the information, or did they gather a bunch of publicly available information and come up with the article on his own? Or did he just pull it out of his ass? Did he just make it up with the intent to harm the campaign? Everything will be relevant. So outside statements made by the author about Trump, about his campaign, will also likely be admissible, and they will be investigated. If there was various derogatory, negative, insulting statements about the campaign or Trump, all of that will come into trial to demonstrate actual malice, that the article was published with reckless disregard or with knowing falsity with the intent to harm the campaign. So everything pretty much can come in. Now, my view is probably the case will fail in New York. It will likely be appealed to the Supreme Court. Whether they'll take it up, I have no idea. It is possible that SCOTUS may want to revisit the Sullivan Standard. It's over 50 years old. They may want to take a look at it one more time, review its consequences over the past 50 plus years. Potentially this case may have a novel legal question, such as, can the publisher sustain liability for an op-ed that it claims to be opinion but actually crosses into the factual assertion realm? So can liability lie for that kind of thing to the publisher? That could be a novel question. We'll see. I have no idea. This is a test case, obviously. There will be many others. So if any of them succeeds on whatever basis, then we're likely to see a deluge of similar cases filed by other public figures. against various media outlets, so watch out for that. So a lot of scholars believe that the Sullivan Standard really went overboard. It's too broad, protects the media too much. They're basically able to publish whatever they want about anybody they want, you know, destroy their reputation, expose them to humiliation, pretty much anything they want, and then they could just say, oops, opinion, sorry, can't sue, just opinion. So a lot of people believe that that kind of protection should be limited to a reasonable extent somewhat at this point, because it's really gotten out of control. So I should mention that pretty much every single other Western country does not acknowledge the Sullivan Standard. They do not acknowledge a parallel system of justice for public figures and private. They have the same requirements for defamation for both private and public figures. So a lot of them expressly reject the Sullivan case, particularly in the UK, where it's much easier to sue for defamation. So, you know, a lot of people think that the Sullivan Standard is untenable at this point, and the media needs to be reined in. And, you know, I personally believe that the right to print and publish is not unlimited. It needs to be, you know, reasonably circumscribed. And so there is a point beyond which the media should hold some liability for what they publish, because it really has gotten absolutely absurd at this stage. One more item I do want to mention is that the attorney for the Trump campaign, for the plaintiff, is Charles Harder. Okay, so if you don't know that name, then that is the guy, the lawyer who killed Gawker for Hulk Hogan. So definitely this is someone who is an expert in defamation law. He knows what he's doing, as opposed to me. I'm definitely not an expert in defamation law. So this is an interesting case. It is going to be one of many. I'm going to follow it, see what happens. So I think that's about all. I'm going to cut it off at this point. I hope this has been interesting and informative, or one or the other, whichever. So I will see you in the next video, and thanks for watching. Like, subscribe. Peace out. Stay frosty, my friends.